Welcome back, everybody. In the first half of this week's lecture, we began our investigation of the three branches of the United States federal government with a discussion of the legislative branch. In this lecture, we're going to take a step forward and begin to examine the judicial branch. So let's go ahead and get started with our overview. In today's lecture, we are going to try and answer each of the following questions. Number 1, what are the key functions, components, and structural features of the judicial branch? Number 2, what is judicial review? Where did the power to exercise judicial review come from, and why is it important? Number 3, what are the different types of courts in the judicial branch, and what sorts of cases does each type of court hear? Number 4, by what process does the Supreme Court of the United States agree to hear a case, and what factors influence how a justice rules in a particular dispute about the law? Finally, what are the different types of jurisprudence? How are they different? And what methods of constitutional interpretation does each form of jurisprudence tend to prefer? Let's go ahead and start with that first question. What is the judicial branch, and what are its key functions? Well, the judicial branch is that portion of our federal government comprised of the courts and constitutionally charged with resolving disputes about the law. Remember my example about the fender bender in week 1's lecture content. If there's a car accident and neither motorist can agree who is at fault, they can go to the courts and find out what the law has to say about their particular case. So another way to put this is to say that the judicial branch's core function under the Constitution is to interpret the law and tell us how the law applies to our specific cases. A case, by the way, is really just a dispute. In this case, a dispute about the law. Now, this is an important point to make because it's going to help us to make sense of a critical concept called judicial review. There are a lot of very complicated ways that scholars have attempted to explain the concept of judicial review, but here is the definition that I want you to remember. Judicial review is the power of the courts to resolve disputes about the constitutionality of a law or other government action. I'll say that again. Judicial review is the power of the courts to resolve disputes about the constitutionality of a law or other government action. And judicial review is also the most powerful tool at the disposal of the judicial branch. Because what we are going to discover is that judicial review is the main way that the courts, and in particular the Supreme Court, achieve two of their unspoken goals. What are these goals? Well, the first goal of the courts, and in particular of the Supreme Court, is to check the other branches of our government. It wants to keep the other branches from getting too big for their britches. And the main way that it can do so is by exercising its power of judicial review to rule that the behaviors of actors or decision makers in the other branches are unconstitutional. The second sort of unspoken goal of the courts is to play an active role in shaping public policy, which of course should again ring some alarm bells for some of you, because remember, under our Constitution, the judicial branch isn't supposed to be playing an active role in shaping our public policy. It's not supposed to be making the rules that we live under. It's just supposed to resolve disputes about what those rules say, what they mean, or how they apply to a particular case in controversy. Making the law is not the job of the courts. That's the duty given by our Constitution to the legislative branch of our government, to Congress. But remember from our discussion of federalism that the supreme law of the land is the United States Constitution. And, as I've told you, the power of judicial review basically allows the courts to engage in what we call judicial activism by authorizing them to tell us what the Constitution says. Think about it. If I have the power to decide whether a law is unconstitutional, that necessarily insinuates that I also have the authority to say something about what the Constitution means, to interpret the Constitution. I cannot decide if, for example, an executive order, a treaty, or a piece of legislation violates the Constitution unless I am also allowed to make determinations about what the Constitution does and does not say. So, because of judicial review, for all practical purposes, the supreme law of the land is not the Constitution itself, not per se, but rather the Constitution as interpreted by the courts. And that makes the courts very, very powerful, because they now have the ability to shape the policies that we live under by choosing how they want to interpret the Constitution in any particular case. And while we can hope that they won't abuse this authority to, say, twist the meaning of the Constitution for their own ideological ends, that's not the reality of the situation. What we're going to discover is that the political beliefs of a judge or justice on the Supreme Court or elsewhere in the judicial branch do seem to play a very big role in shaping how that judge or justice rules. And all of this is very interesting because judicial review is not actually a concept that is ever directly mentioned in the Constitution itself. Rather, it is a power that the judicial branch claimed for itself in the 1803 Supreme Court case of Marbury versus Madison. Now, we're not going to go into the details of this case because those are going to be discussed by your reading, but do understand that in this case, the Supreme Court created the concept of judicial review, which in turn makes the courts very powerful by, once again, opening up the door for judicial activism. What that means is that the creation of judicial review in Marbury versus Madison allows the courts to essentially legislate from the bench, to play a very active role in shaping the laws that we live under and in checking the other branches of the government. So the significance of Marbury versus Madison is that it created judicial review, and judicial review is critically important because this is the main tool used by the courts to engage in judicial activism, the shaping of the rules we have to live under, and to check the other branches of our government. So at this point, we know what the judicial branch is, and we know what it does as well as the main tool that it uses to do so. Then, it logically follows that we might proceed by taking a moment to pause and talk about how the judicial branch is organized. Because what we are going to discover is that the structure of the judicial branch is somewhat complicated. It is complicated because most of the judicial branch was created by Congress over time as the need arose without necessarily having a clear plan, course of action, or understanding about what the future would bring. When the Constitution created the judicial branch, it didn't actually tell us very much about what the judicial branch would or should look like. It basically says that there will be a Supreme Court and, I quote, whatever other courts Congress shall make, end quote. Which, of course, isn't out of the ordinary. Remember that the Constitution was kept intentionally vague. And one reason why it was kept vague was that the Founding Fathers knew that they could not possibly see the future. So they wanted to make sure that there was a way to adapt the structure of the judicial branch to new and unforeseen challenges. Like, for example, the rapid expansion in the size and population of our country, and therefore in the number of cases that would need to be resolved. One thing that the framers did know was that there would quickly come to be far too many cases for just one court to hear. So, we knew that we would need many different courts, as well as a system for deciding which courts will hear which cases. And so, over time, we developed a very complicated judicial structure that organized new courts into distinctive jurisdictions or realms of authority. For example, the first two major characteristics of the judicial branch that you need to be familiar with, the first of the two major characteristics of the judicial branch that you need to be familiar with is what we call the dual court system. The dual court system can be defined as the division of the judicial branch into both federal courts and 50 independently functioning state court systems. One more time. The dual court system can be defined as the division of the judicial branch into both a federal court system and 50 independently functioning state court systems. Basically, what this means is that we have 51 separate court systems in the United States. We have the federal court system, which has federal jurisdiction. Federal jurisdiction is the authority to hear cases and resolve disputes about federal laws, to include acts of Congress, presidential actions, treaties, and the United States Constitution. So if you have a dispute about, say, whether or not a particular policy violates your constitutional right to free speech, well, that case would fall under federal jurisdiction because the Constitution is a federal law. What that means is that you would take your case to a federal court. But what if you had a dispute about whether or not a recent city ordinance violated your rights, not as a U.S. citizen, but as a citizen of Oklahoma under the Oklahoma State Constitution? Maybe you think that the policy does not violate the United States Constitution, but it does violate the state constitution. Well, in that case, you wouldn't go to a federal court. You would go to an Oklahoma state court. Every state has its own court system, and the court systems within each of the states has state jurisdiction. State jurisdiction is the authority to hear cases and resolve disputes about state laws. Oklahoma courts resolve disputes about Oklahoma laws. Texas courts resolve disputes about Texas laws, so on and so forth. So we have one court system for each state to help resolve disputes about that state's laws, and then a separate, independently functioning federal court system to help resolve disputes about federal laws. This is the dual court system, and that's the first of the two major structural features of the judicial branch that I want you to be familiar with. In addition to this feature, however, you should also be aware of a second critical component or characteristic. The judicial branch has a hierarchical structure. It is organized into a system of 3 tiers or steps, each comprised of its own particular types of court. At the bottom of this hierarchy, we have the trial courts, which are sometimes called district courts. We call them district courts because each one has jurisdiction to hear cases emerging in one of the 94 judicial districts around our country. The 94th district has a trial court that helps resolve disputes about federal laws emerging in the 94th district. It does not hear cases originating in any other of the 93 alternative districts. Similarly, the trial court for the 1st judicial district can hear cases which originate in that district, but it cannot hear cases or issue rulings on a dispute that originates in the 92nd district or the 40th district. The 2 most important things you need to know about trial courts have to do with their jurisdiction. First, they only have original jurisdiction, the authority to hear cases and issue rulings over their own district. The second thing that I want you to know is that they have what we call, again, original jurisdiction. So first, they only have jurisdiction within their own district. Second, they only have original jurisdiction. Original jurisdiction is the authority to make an initial ruling on a case. So think back to our fender bender example. We have a dispute, a case, and we need the courts to help us resolve this disagreement. Are we going to go straight to the Supreme Court? No. We'll start at the bottom in a district court, and that court will make an initial ruling. Similarly, if I felt like Congress had passed an unconstitutional law, I would start by bringing a lawsuit to challenge this law, again, in a district court. But what happens if the district court does not rule in my favor? Do I have to stop there? No. If I still feel that my rights or the Constitution is being violated, I can appeal the decision and move up to the second tier or step in this three-tiered hierarchy of the judicial branch. The second tier is comprised of 13 appellate courts. The 94 district courts are all organized into a series of 12 regional circuits. Each circuit has its own court of appeals. For this reason, the appellate courts, or courts of appeals, are also sometimes known as circuit courts. And each of these circuit courts is in charge of hearing appeals that emerge from one of the district courts within its circuit. So each one of these circuit courts hears challenges to district court rulings located within its circuit, with the single exception of the 13th Court of Appeals, which has nationwide jurisdiction in a limited number of special cases. For now, though, let's ignore that 13th Court of Appeals because it's an exception to the general rule, and I don't want it to confuse you. We've got at least 12 circuit courts, each of which has jurisdiction to hear appeals to the decisions of district courts within its own circuit. Now, when we are talking about appellate courts, you won't be surprised to learn that they only have appellate jurisdiction. What that means is that they are allowed to review and either uphold or overturn the decisions of a lower court within their circuit, but they do not get to make an initial ruling. In other words, you'll never start in a court of appeals. By and large, you're going to start in a district court, and if you don't like the ruling of that court, you can appeal to the circuit court, which will then determine whether or not the law was applied and interpreted correctly by the lower court. But the Court of Appeals does not have original jurisdiction, so it cannot hear a case that has not already gone through a lower court. But again, this isn't the end of the hierarchy. There's one more level. So let's say that the circuit court upholds the district court's decision, and I am still dissatisfied. Well, I can file a second appeal and try to get my case from the circuit courts to the United States Supreme Court, which has the final say in how to resolve a dispute, interpret, or apply the law. At this point, I wanted to pause and let you know that the Supreme Court does fulfill several very important special functions within the broader mission of the judicial branch as a whole. The judicial branch as a whole helps us to resolve disputes about the law, and the Supreme Court does this as well. But it's a little bit different than any other court in that its decisions have far more far-reaching consequences. So there really are going to be several things that I want you to know about the Supreme Court, and that means that you should have your note-taking supplies at the ready. First, I want you to know that the Supreme Court is the highest court. If you do not like their ruling, though, tough luck, right? There is nobody else that I can appeal to once the Supreme Court has ruled against me. Short of a constitutional amendment, nobody has the constitutional authority to overturn a decision of the Supreme Court once it has been handed down. Second, the Supreme Court is, generally speaking, the only court with national authority. Remember, district courts have jurisdiction over their own districts, and circuit courts have jurisdiction over their own circuits. A ruling in the Ninth Circuit Court is only going to be binding to people who live in that particular part of the country. It's not going to affect you if you live in any other circuit, right? So again, it doesn't affect you or any of the district courts in any other part of the country. Consequently, the Supreme Court has a special mission of resolving disputes between other courts. If one circuit court says that gay marriage is a right and another circuit court says no, it's not, neither one has the authority to overturn the other's decision. And what that means is that people living in one circuit will be able to enjoy a right, in this case, same-sex marriage, that people in another part of our country do not get to enjoy. And this kind of inconsistency in the law can be somewhat hard to resolve because, again, neither circuit can impose its ruling on the other. But the Supreme Court can, and in this case, it did. So the third thing that I want you to know about the Supreme Court is that one of its special functions within the broader mission of interpreting the law is to establish a nationally uniform interpretation of the law. The fourth point I want you to take down relates to this. In addition to helping us to establish a nationally uniform interpretation of the law, the Supreme Court also provides instructions to all lower courts about how they should interpret the law in similar cases. If the Supreme Court says that gay marriage is a constitutionally protected right, every lower court has to comply with this understanding of what the Constitution says. They do not have the authority to challenge the Supreme Court's interpretation, although in practice, a lower court will occasionally get a little big for its britches and try to do so. Usually, though, when they do that, the decision is immediately appealed and stricken down a second time. Anyway, the next thing that I want you to note is that the Supreme Court is the only court in the entire country with both original and appellate jurisdiction. However, its original jurisdiction is extremely limited. The Constitution explicitly tells us that the Supreme Court shall have original jurisdiction in a handful of specifically listed cases and appellate jurisdiction in all other cases, and I quote, with such exceptions and regulations as Congress shall make, end quote. Now, this is important for a couple of reasons. First, it means that the Supreme Court has very limited authority to make an initial ruling on a case. Basically, if the case doesn't involve some kind of public minister, like an ambassador, and if a state is not a party to it, the Supreme Court doesn't have original jurisdiction. It can still hear the case, but not until such time as that dispute has already gone through a lower court and been appealed to the Supreme Court. Second, it means that the vast majority of the Supreme Court's authority to hear cases and issue rulings, its appellate jurisdiction, is defined by Congress. Outside of those particular cases over which the courts are given original jurisdiction by the Constitution, the courts are only allowed to hear those particular cases that Congress has authorized them to hear. And that applies to the Supreme Court as well, right? Which opens up the door for what we call jurisdiction stripping. Jurisdiction stripping. Jurisdiction stripping is a way in which Congress can attempt to check the judicial branch by stripping it of its jurisdiction to make rulings in certain types of cases. Now, jurisdiction stripping was intentionally included in the Constitution as a check on the abuse of judicial power, but I do want to note something that's kind of important. It's never actually been used, right? One way or the other, to summarize, the Supreme Court, 1, makes final rulings. 2, provides instructions to lower courts about how to interpret the law in order to create national uniformity in the policies that we live under. 3, has limited original jurisdiction. And 4, has expansive appellate jurisdiction that can theoretically be limited by Congress. Now, at this point, we're almost ready to start talking about the process by which the Supreme Court of the United States agrees to hear a case and what sorts of factors influence the way in which justices rule in those cases that they do agree to hear. But one of our learning objectives for this week asks that you be able to pick out what sorts of cases would be heard by which kinds of courts or under what sorts of jurisdiction. And we've already discussed how to distinguish between cases that would be heard under appellate jurisdiction by a circuit court or original jurisdiction by a district court. If the case has never been heard before, it's under original jurisdiction and goes to a trial court. If the dispute has been heard before and you're appealing the decision of a trial court, well, then it'll be heard again, this time under appellate jurisdiction, and generally that means that you're going to be going to a circuit court. Simple. But we haven't fully discussed what types of cases will be heard by state courts under state jurisdiction and what types of cases will be heard by federal courts under federal jurisdiction. Because what you will find is that this three-tiered hierarchy of courts characterizes not just the federal court system, but the court systems of our states. Just as there are district courts, circuit courts, and a Supreme Court for the United States as a whole, so too is there going to be 77 district courts, 5 circuit courts, and 1 Supreme Court for the state of Oklahoma in particular. So if I have a dispute that's never been resolved before, maybe I understand that I need to go to a district court. But how do I decide whether that should be a federal district court with federal jurisdiction or a state district court with state jurisdiction? Well, real quick, I'll go ahead and give you 3 general rules that you can use to figure this out for any particular case. If your case involves any one of the following, a federal question, a diversity of citizenship, or a dispute between states, then it goes to federal courts. Everything else goes to a state court. But let's break that down a little bit further. When does your case involve a federal question? Well, a federal question is a dispute about federal law. So if you're challenging a government action by the United States President, a bill signed by the United States Congress, a U.S. treaty, or any other source of federal rather than state policy, yes, you have a federal question. In that instance, you go to a federal court because state courts do not have the authority, the jurisdiction, to hear cases or issue rulings about federal laws. Next on our list is the diversity of citizenship. To have a diversity of citizenship, a case must involve disputants from more than one state. So if you've got an Oklahoma business owner in Durant being sued by a Texas citizen, that's a diversity of citizenship, and we would go to the federal government, which again makes sense if you think about it. After all, we don't just want courts to resolve our disputes, we want them to resolve our disputes fairly. Think back to the first week's lecture. Courts need to provide a neutral mediator, and to be a neutral mediator, the court cannot have a dog in the fight. But you can't really say that an Oklahoma court or a Texas court doesn't have a dog in this fight, because you can't trust the Oklahoma courts to be free to the Texan or the Texas courts to be fair to the Oklahoman. Each one has a reason to prefer protecting the citizens of its own state over those of other states. So in this instance, we default to the federal government, which again can hopefully be a bit more impartial because it doesn't care whether the Oklahoma citizen or the Texas citizen wins. It has no dog in the fight. The same logic applies to a lawsuit between 2 states. For example, Oklahoma and Nebraska are both currently in a legal dispute with Colorado over that state's decision to defy federal law and decriminalize marijuana. Now, however you feel about Colorado's decision and what it's done, we can't trust Oklahoma's courts to rule against their own state or Colorado's courts to rule against their own state. So again, we go to the federal government, which doesn't have a dog in the fight and can therefore provide us with a neutral mediator that will theoretically mediate the dispute fairly. And that's pretty much all you need to know. If you want to figure out whether your case belongs under federal jurisdiction, ask yourself, does it involve a federal question? Does it involve a diversity of citizenship? Does it involve a dispute between 2 or more states? If your answer is yes to any one of these questions, well, that's a federal case. But if you say no to all 3 questions, then it's a state case. Pretty straightforward. So now that we're done talking about jurisdiction and the organizational structure of the judicial branch as a whole, let's narrow the scope and start to look at the Supreme Court in particular. Now, I have already told you a little bit about this court and what it does. It establishes the uniformity of law and provides instructions to lower courts about how to interpret the law, and it makes final decisions about how we should understand or apply the law in particular types of cases. But specifically, how does it go about doing so? Well, the short answer to this question is that the Supreme Court provides these instructions and fulfills these functions by, first, hearing a case, and second, issuing opinions on those cases. In this context, the term opinion might be defined as a public declaration of the court's ruling on a case and the reasoning behind that ruling, which provides instructions to all lower courts about how to rule on or interpret the law in all similar cases. I'll go ahead and repeat that. In this context, an opinion of the court is a public declaration of the court's ruling on a case and the reasoning behind that ruling, which provides instructions to all lower courts about how to rule on or interpret the law in similar cases. So, if the Supreme Court hears a case on gay marriage and issues an opinion saying that gay marriage is a constitutionally protected right, all the other courts know from that opinion that they should also interpret the United States Constitution as protecting same-sex marriage in all future cases about same-sex marriage that are brought to their attention. One thing that is important to understand about this, however, is that before the Supreme Court can issue an opinion, it has to hear a case. And the Supreme Court is neither willing nor authorized to hear just any case. For example, the United States Supreme Court clearly does not have the authority or jurisdiction to resolve a dispute between, let's say, two French citizens about the interpretation and application of a French law in France. It just doesn't. Again, in the United States, courts can only hear cases and issue rulings on disputes within their jurisdiction. And for the Supreme Court, that usually means that we're looking at a dispute that has already been heard by a lower court, because remember, the Supreme Court has extremely limited original jurisdiction. 99% of the time, if a case has not already been considered by a lower court, the Supreme Court simply does not have the jurisdiction to hear that case. So 99% of all of the cases that it is going to hear are going to be heard on appeal after consideration by at least one lower court. However, even if we can establish that the Supreme Court does have jurisdiction to hear our case, that doesn't mean that it's going to do so. What we will discover is that the Supreme Court is actually very particular about what sorts of cases it will and will not hear. First off, it will only hear cases that involve what your textbook describes as a justiciable controversy. A justiciable controversy. That's kind of a confusing term. I prefer the phrase a case in controversy, but either way, a justiciable controversy, a justiciable case, or a case in controversy is any dispute over an actual law or action of the government in which a real person has already suffered an actual meaningful injury. So again, a case in controversy or a justiciable controversy is any dispute over an actual law or action in which a real person has already suffered an actual injury. In other words, the court simply does not hear hypothetical cases. You cannot bring a case before the Supreme Court because you think that a policy which was recently passed might one day violate your rights, or that maybe someday a policy that nobody has really talked about will be created, and that once it has been created, then it might harm you. No, that's not going to fly. You have to wait until after the policy has already been made, passed into law, and has already caused you a real, meaningful injury before you can challenge that policy in a court of law. Do note, however, that an injury in this context does not necessarily have to be physical. It certainly can be, but it might also be a legal injury. Maybe one of your rights has been violated, but you have not been physically harmed. Perhaps, for example, one of those lower courts has told you that you will not be allowed to marry a same-sex partner on the basis of your sexual orientation. That would, legally speaking, be considered a meaningful injury, even though your bodily well-being has not been affected, because the Supreme Court has ruled that same-sex marriage is a constitutionally protected right. So you've suffered a legal injury, even though physically speaking, you are still uninjured. Of course, even if there is a case in controversy, that case must also be brought before the court's attention by a litigant with standing. Let's break down those two terms. To litigate, if you don't know, is just to bring a legal action before a court. A litigant, then, is the person who brings that legal action. If you file an appeal, you are the litigant. But before your case can be heard, you must demonstrate that you have standing. Standing, in turn, is the right to have your case heard before a court of law. And in order to establish standing, you need to prove first that you are the person who has been affected by the policy you are challenging, and that you have already suffered a real injury. Again, what this means in practice is that there will be no hypothetical cases. The court does not issue advisory opinions. But in this instance, it also means that you cannot sue on somebody else's behalf. I cannot challenge a state policy prohibiting same-sex marriage because it violates my cousin's right to marry his boyfriend. He would have to bring that lawsuit himself. Nobody else could do it on his behalf because they would not have standing in that case, since they are not the person who was actually injured. Finally, of course, we need to ask ourselves whether this is a case that the Supreme Court even wants to hear. Just because it can hear our case doesn't mean that it will do so. I can jump off a bridge. I am perfectly capable of doing so, but I don't want to. Right? And the Supreme Court works the same way. What we're going to find is that the Supreme Court probably doesn't want to hear our case, because the Supreme Court only agrees to hear something like 1 in every 4,000 or so eligible cases that are brought to its attention. Now, a part of this does have to do with ideology. The justices have their own ideological goals that they want to fulfill, and they are going to choose to hear those cases that give them the greatest opportunity to do so. But a much, much bigger part of the problem is that there's only one Supreme Court, and yet we've got an essentially infinite supply of disagreements about the law. For practical purposes, just logistically speaking, it's simply not possible for the Supreme Court to hear all of the cases that people bring to its attention. And so the Supreme Court has to prioritize some types of disputes over others. And what types of disputes do they tend to prioritize? Well, what we're going to find is that there are 3 types of cases that the Supreme Court tends to focus on. The first type of case that the Supreme Court is most likely to hear is one involving a nationally charged controversy like gay marriage or the Affordable Care Act. So if this is something that the entire country cares about and is talking about, then the Supreme Court is more likely to weigh in. Second, the Supreme Court is more likely to hear a case involving what we call a circuit split, or a disagreement between at least 2 lower courts. So again, sticking with recent examples, if one circuit court rules that gay marriage is a right, another circuit court says no, it's not, that's a circuit split, And the only one with the authority to resolve this inconsistency will be the Supreme Court, and so the Supreme Court is much more likely to agree to hear that case. Third, the Supreme Court is more likely to hear cases in which a lower court has defied prior instructions provided by the Supreme Court through its previous opinions or precedent. Okay? That's not very common. It does occasionally happen. And when those lower courts do get a little big for their britches and decide to defy the Supreme Court, it's pretty willing to accept those cases, if only to put the lower court back in their place. Okay? One way or the other, if your appeal does not fall into one of these three categories, it's simply not very likely that you're going to make it to the Supreme Court. But let's say that you will ultimately make it to the Supreme Court. What then will this process look like? What can you expect? What are the specific steps that the court is going to go through in agreeing to hear your case and ultimately in issuing an opinion on your case? Well, the first step is to issue a writ of certiorari. A writ of certiorari is basically just a written invitation to have your case heard before the court. In order to get the writ of certiorari, you need to satisfy the rule of 4. That means that you need to get at least 4 justices to agree that your case is worthwhile, that they want to hear it. Now, you will notice that I did not say 4 of the 9 justices. I just said 4 justices, and there's a reason for that. It is true that currently there are 9 seats on the bench. What that means is that most of the time we will have 9 sitting justices on the Supreme Court. Okay? However, while it is true that when there are 9 sitting justices, you will need 4 of those 9 justices to agree to hear your case before you can get the writ of certiorari, it may also be true that there is a vacancy on the court. Right? And what if there is a vacancy on the court, as we saw recently after the passing of former Associate Justice Antonin Scalia? Well, in that case, you still need 4. You need 4 of the 8 remaining justices. And that makes your life a little bit more difficult, because getting 4 of 9 justices to agree to hear your case tends to be a little bit easier than getting 4 of 8 justices, because you've got that extra opportunity for a yes. I'd like to hear this case. This point, right, is going to come up again momentarily, so don't forget it. But remember, to get the writ of certiorari, you must get at least 4 justices to agree to hear your case. And this is true whether we have a full bench or we have a bench that has been atrophied in its numbers by a certain level of vacancy. Okay? Either way, once you've gotten a writ of certiorari, the next step is for the court clerks to do their research. The clerks are basically legal professionals who gather all of the necessary arguments and information about the dispute, compile it into a synopsized report, and hand that report over to the justices. The justices will then read through these reports before moving on to the next step. Now, one part of what the clerks will take into consideration while conducting their research and writing their reports for the justices are what we call amicus briefs. Amicus briefs are basically advisory opinions submitted to the court by interested third parties with explanations for how those interested third parties think the justices should rule. Amicus briefs are not legally binding, but justices will often use them as a way to try and see both sides of an issue. So amicus briefs often influence the way that justices rule in a particular case. In any case, after they are done researching, the next step is for the case to go to oral arguments. Now, oral arguments used to be very important, but today they're frankly more of a formality. By this point, the justices have done their research, and by and large, you know how they're going to rule. But traditions are important, so each side is still given a few minutes to make its case before the 9 justices, before a final decision is handed down. After oral arguments, the justices meet and try to come to an agreement. It is at this point that the court has to make its decision. And it is at this point that we need to discuss the rule of 5. The rule of 5 basically says that it takes at least 5 votes to win a case. In other words, if you want the court to overturn a lower court's decision, or to rule an act of Congress unconstitutional, or to rule an executive order or any other government action unconstitutional, you are going to need at least 5 justices to rule in your favor. Now, again, you'll notice that I'm not saying 5 of 9, because again, if there's a vacancy on the court, it might actually be 5 of 8, or if there's 2 vacancies, 5 of 7. And recent politics has shown us that this is really important. What we will find is that the Supreme Court is completely capable of functioning with 8 or even 7 justices. There is literally nothing in the Constitution which requires 9 active justices on the Supreme Court for it to operate. It can still hear cases and issue rulings or opinions on those cases with 1 or more vacancies. But remember that the main way that the court engages in judicial activism and checks the other branches is by ruling that their actions are unconstitutional, which, as I have just told you, it can only do, according to the rule of 5, if at least 5 justices sign on to the same opinion explaining why that government action is unconstitutional. What this means then is that when there is a vacancy on the court's power is somewhat more restrained than usual. It is, again, harder for the court to get 5 of 8 justices to sign on to an opinion ruling an act of Congress unconstitutional than it would be to get 5 of 9 justices to do so on the exact same policy. If there are 8 justices, you might have a 4-4 tie. And then what happens? Well, the law is upheld. So with 9 justices, that's an odd number, you get that tiebreaker. And if the tiebreaker rules against you, well, no harm done, you would have lost anyway. But if they rule for you, well, now the court is playing a bigger role in shaping policy. Now that congressional law has been overturned, has been ruled unconstitutional, and the legislative branch has been checked. However they go about getting the 5 justices to agree, the final step is to issue the opinion. Now, I'm going to briefly note something. There are technically many different kinds of opinion that the court or a justice on the court can issue. And we don't have time to talk about them all here. But I do want you to be familiar with each of those types of opinions, so make sure that you are keeping up with your assigned readings, because this may very well come up on your quiz for this week or for our first exam, which isn't that far off, by the way. Now that we know about the procedure by which the Supreme Court operates, by which it agrees to hear a case and issues rulings, let's take some time to talk about the factors which help to explain why the justices on the court rule in the ways that they do. Because if you take a moment to think about it, there is something of a puzzle here, right? Remember what I told you earlier. The court is supposed to interpret the law. It is not, constitutionally speaking, supposed to play an active role in shaping what laws mean or what laws we live under. They just help us to figure out what those laws happen to say about our particular cases. But if they're just interpreting the law, why then do justices sometimes come to contradictory conclusions? If they're just applying the Constitution, for example, why is it that some of them will rule to uphold the Second Amendment, whereas others tend to favor gun control policies? We only have one Constitution, and it either does protect the right to keep and bear arms, or it does not, right? So then their job should be pretty easy. If it does, then all 9 justices should vote in defense of that right. If it does not protect the right to keep and bear arms, then theoretically, none of the justices should attempt to create that law, to create that right to keep and bear arms. Because remember, they're interpreting the law. They're not, constitutionally speaking, supposed to change or shape the law. But what we are going to find is that justices are not always the neutral interpreters of the law that they like to play themselves off as. They each have their own set of ideological goals and perspectives, and these ideological goals and perspectives help to shape, bias, or otherwise influence the decisions that they make. And these factors, in turn, help to explain why some justices will say that abortion is a constitutional right, whereas others will say, no, it's not. What then are the main factors influencing how a justice rules and explaining why different justices sometimes come to different conclusions about what the law says in a particular case? Well, the empirical literature suggests that the two most important predictors of where a justice falls, how a justice decides to rule in a particular case, are that justice's judicial philosophy and political ideology. And we're going to talk about each of these in turn. The term jurisprudence or judicial philosophy, those are synonyms, right? The term jurisprudence refers to the belief of a justice about the proper role of the court and the appropriate use of judicial review. Again, jurisprudence or judicial philosophy is the justice's beliefs about the proper role of the court and the appropriate use of judicial review. Remember, judicial review is the power of the court to resolve disputes about the constitutionality of a law. And there are really two big types of judicial philosophy. First, there is judicial restraint. Judicial restraint is a type of judicial philosophy which basically says that the appropriate role of the court is to fulfill its strictly constitutional role of interpreting and resolving disputes about the law. In other words, a judicial restraintist believes that justices should act like umpires. If you know anything about baseball, you understand that umpires don't make the rules of the game, they just apply them. Judicial restraints says that the court should act in the exact same way. Under our Constitution, making laws and shaping public policy is Congress's job. The court should not overstep its constitutional bounds by abusing judicial review to take over Congress's domain and begin, quote unquote, legislating from the bench. We call this particular type of jurisprudence judicial restraint, or sometimes judicial constraint, because it constrains the power of an individual justice to use the court or judicial review as a means by which to achieve his or her own ideological and political goals. The justices don't really get to exercise a lot of discretion because they're not writing or creating or changing the laws. They're just applying laws written by the legislative branch. They're simply telling us what the Constitution literally says. Okay? The second major type of jurisprudence or judicial philosophy is what we call judicial activism. Judicial activism is a type of judicial philosophy which says that justices need to go above and beyond their strictly constitutional role as interpreters of the law and use their power of judicial review to play a more active role in checking the other branches of government and shaping public policy. In other words, it's not enough just to apply the law. You need to try and actively improve the law by using judicial review to interpret the Constitution in whatever way suits your particular ends and keeps the other branches from becoming too strong, too active, or too contrary to the democratic aspirations of the framers who wrote our Constitution. We call this judicial activism because it allows the justices to play a more active role in checking the other branches and influencing the laws that we live under, for better or worse. Now, jurisprudence should not be confused with political ideology. The two concepts do tend to be related. People who have a conservative political ideology usually prefer judicial restraint, whereas liberal justices tend to favor judicial activism. But that's not always the case, and the two concepts are not synonymous. Judicial philosophy refers to your beliefs about the appropriate role of the court and the proper use of judicial review. Political ideology, by contrast, is significantly broader. We'll elaborate on political ideology later on in the semester, but what we're going to find at this time is that an ideology is simply a broad set of general beliefs or values or ideas about how society should be governed. Conservatives tend to believe in limited government that mostly lets people alone, especially in the economic sector, while liberals generally believe in a more active government that plays a bigger role in helping us to solve our problems and achieve our goals. And what we're going to find is that while it probably shouldn't, political ideology does play a big role in shaping how justices rule. They usually don't like to admit this, but statistically speaking, conservative justices tend to uphold conservative policies and strike liberal policies, while liberal justices tend to do the opposite. And it's worth noting that because liberals are more likely to be activists than conservatives, they do tend to be more willing to factor in their own ideologies when deciding how to rule, but this isn't always the case. And again, a lot of that does have to do with jurisprudence rather than political ideology. One way or the other, these are the two major factors which decide how a particular justice rules in an individual case. Because what we're going to find is that different types of jurisprudence tend to favor different methods or approaches to interpreting the Constitution. Remember, restraintists believe that the court should be constrained, that it should not try to overstep its strictly constitutional boundaries, that it should be fairly limited. Activists, on the other hand, want the court to use its power to interpret the law in such a way that it helps to achieve ideological goals and check the other branches of government. But neither side is going to say, let's ignore the Constitution altogether, at least not overtly, right? Although some scholars have argued that behind closed doors, that is basically what they're doing, right? They're pushing their own ideology out there, and they are cloaking it in the law. One way or the other, what we find, though, is that justices, right, tend to interpret the Constitution in a way that suits their own ends. If I want a restrained court, I'll tend to prefer methods of constitutional interpretation that do not leave a great deal of room for the individual justices to exercise a great deal of discretion or to put their own experiences, beliefs, or ideologies into the decision. If I want an active court, I'll try to interpret the Constitution in a more liberal manner. But even within these two distinctive jurisprudences, there are some disagreements about how to interpret the Constitution. And this is where your handout is going to come in handy. But I want to supplement that by closing today's lecture with a bit of discussion about each of these different theories of constitutional interpretation. We'll start with the strict construction or strict interpretation methods usually favored by restraintists and conservatives. The first strict or restrained theory of constitutional interpretation is what we call textualism or literal meaning. When applying this method of constitutional interpretation, you do not factor in your own opinions or perspectives. You just ask yourself, what does the Constitution literally say based on the laws of the English language and grammar? If it says that a law or an act of Congress is unconstitutional, you should rule that that act of Congress is unconstitutional. If it does not explicitly say that a law or act of Congress is unconstitutional, you should not rule that that act of Congress is unconstitutional. Again, if you're a justice in this case, there's not much room for you to exercise discretion. You're basically just an editor or an English teacher. But we also have another strict interpretation of the Constitution called original meaning, which is similar to textualism, but says that instead of focusing on the literal meaning of the words in the Constitution based on the laws of language and grammar today, we need to apply the laws of English that existed at the time that the Constitution was written. Again, there's very little wiggle room here for you if you are a justice. You are an umpire. There are a set of rules for 18th century English, and you use those rules to interpret the Constitution. Your own thoughts will never enter into the equation, at least not in theory. After that, we've also got original intent, and this one's a little bit interesting. Original intent is still fairly constrained, but not quite as constrained as the first two theories of constitutional interpretation that we have discussed today. Basically, it says that we need to focus on what the Constitution was intended to say, what it was intended to do. It's not enough to ask what the framers included in the Constitution. You also need to ask yourself why they included it in the Constitution. Let me give you an example. If I were to take an original meaning approach to interpreting the Constitution, I could argue that when the First Amendment was written to protect our freedom of the press, it was meant to apply, or it did apply, only to newspapers. Why? Because at the time that the Constitution was written, the term press was used in reference to a literal piece of technology called the printing press, which was used to mass produce printed media. But what we understand is that the framers weren't concerned about protecting a specific piece of technology. It wasn't the printing press itself that they were concerned with. It was the freedom to share ideas that the government did not necessarily like or want us passing around. So applying an original intent approach to the First Amendment's protection of free press, justices have tended to rule that the freedom of the press applies not just to newspapers, but radio, television, and interviews. Okay? Finally, we've got stare decisis, which literally translates to let the decision stand. Basically, this method tells us that we should interpret the Constitution through the lens of prior Supreme Court rulings. You're still not putting very much emphasis on your own goals, but in order to maintain consistency, you will, generally speaking, defer to previous interpretations passed down by the court in its older opinions. Those previous interpretations are what we call precedent. The previous rulings, right, will, according to stare decisis, establish precedent that you, as a justice, should follow in how you interpret the law. None of this, then, allows justices to treat the Constitution like a living, breathing document, to factor in their own ideological goals, or to reevaluate the Constitution in light of changing realities. But judicial activists and liberals have found a large number of broad constructions or broad interpretations of the Constitution which can be used for these purposes. The first activist approach to interpreting the Constitution that we are going to talk about is what we sometimes call polling jurisdiction. And I think that this one is, one of the strangest approaches for most students. Polling jurisdiction essentially says that in deciding whether or not to rule a policy or action unconstitutional, it's not enough to just look at the Constitution itself. You also need to look at what policies are working in the United States and abroad, and then interpret the Constitution in a way that will help to replicate the success of these foreign countries at home. So, for example, we've seen some cases in which Justice Kennedy writes the opinion of the court, and in his opinion, makes multiple citations to the Constitution of South Africa. Right? Why South Africa? Well, because their constitution is very young, but has been exceedingly successful. And Kennedy wants to make sure that we can enjoy that same prosperity here in the United States. So it might not be strictly constitutional in a literal sense, but if you interpret the Constitution in a way that makes its application more similar to that of South Africa, we can still benefit from this decision. And it is therefore, according to this approach, polling jurisdiction a legitimate interpretation. The second activist approach is one that I think we find a little bit more appealing: instrumentalism or modernism. This approach basically tells us that we need to interpret the Constitution in light of recent changes and new developments. So, for example, when the framers wrote the Second Amendment protecting the right to keep and bear arms, the most deadly firearms available to your average citizen was a single-shot rifle. Today, we have automatic firearms. As a result, many instrumentalists argue that we need to reinterpret the Second Amendment so that it does not create practical problems on the ground level when it is applied today. They are concerned that if we do not adapt our interpretation of the Constitution in light of new circumstances, or in this case, new firearm technologies, that the Constitution will eventually become irrelevant and no longer appropriate for governing a modern nation. So here's where we start to see the Constitution being treated like a living, breathing document rather than just a legal document. Well, then we've got pragmatism. And as your handout says, the pragmatist approach to interpretation is to use the Constitution and prior rulings as a cloak to cover up your own opinions. In other words, you want to interpret the Constitution like so many of us interpret religious texts today in whatever way suits our own ends. Right? It does not matter what the Constitution actually or literally says. It doesn't matter what it was meant to say. You should use the power of judicial review to try and achieve desirable outcomes by interpreting the Constitution in whatever way suits your own ends. Now again, and this is Oklahoma, so I think that a lot of us can get very uncomfortable with this idea. But understand that it's not always the most terrible thing in the world. There are many cases which have created and protected rights that we enjoy today, which use a pragmatic approach to interpreting the Constitution. For example, if you look at our ability to access contraception, that comes from a pragmatist case called Griswold versus Connecticut. Legalized abortion originates with a pragmatist case called Roe versus Wade. So depending on your views about these issues, you might actually like or benefit from pragmatism in past Supreme Court rulings. Of course, you don't have to like this. I think that all of us are going to have different ideas about how the Constitution should be interpreted. Just like justices, we'll have our own ideologies and our own judicial philosophies. And just like justices, we will let this influence how we think about and understand the law. What matters for our purposes here is that you know which method of constitutional interpretation relates to what form of jurisprudence or judicial philosophy, and that you understand the two main factors influencing a justice's ruling in a case are his or her ideology and his or her jurisprudence. And with that, we've completed our lecture for this week. Congratulations. I'll see you later.